Good evening, everybody. Let me know if you can hear me and see me. Hello, good evening. Okay. So, tonight, a repressed memory case. It is actually a Supreme Court precedent, although it doesn't really set a precedent per se, I should say, and it's from 1993. So our courts have not really dealt a lot with repressed memory per se. So before I talk about this case, I want to give a little bit of a thanks guys for confirming you can hear me. Okay. So anyway, I just want to talk a little bit. I actually had a subscriber ask me specifically to cover a case on repressed memory and therapy in court cases and find a case on this, cover a case on this. So of course it's something that I should be doing. I want to do, and I have been wanting to do. I talk about it a lot. But of course I kind of forgot that these are actually really difficult cases to find in Canadian criminal court database, because not a lot of them exist. And here's the main reason why. And this case as I explain this case, it should explain it more. It's not because per se it's a pseudoscience that's been debunked. That's not the reason why we don't see a lot of these cases at the high court level. The reason is simple, and it may disappoint you, but basically it is up to the courts, the judges and the juries, because sometimes these cases happen just in front of a judge. So whether it's a judge or a jury, it is up to them to determine if what is deemed a repressed memory or a recovered memory arising from therapy sessions, it is up to the judge or the jury to use their common sense to determine for themselves if those memories are false or true. It's as simple as that. And that decision, the appeal courts will not, that particular decision would be referred to by the appeal courts as one where the judges and juries have deference. I believe I'm using it correctly in the context. Basically meaning that it's a type of decision that an appeal court wouldn't interfere with, will not interfere with, because you can't find an error in law when exercising common sense. Now, however, you can potentially find an error in law when deciding, not necessarily using common sense, but when deciding. So this would be more directed to a judge. So in a judge's verdict, if their verdict shows that they made some sort of error in law when coming to the conclusion that all of the evidence put before them makes them believe that these repressed memories that were recovered years later in therapy are actually true memories of true events, or memories, of even, they decide that they're false memories. If the Crown if somebody finds an error in that particular process and framework, wordplay, an error in their wordplay, then it can be up for appeal. But just the actual deciding whether or not it's real or not, it's a false memory or not, that is not up for discussion, basically, in our courts. So we can talk, you guys can ask me more questions about it later or leave comments about what your thoughts are on this, but I will use this case. This case here, R versus Norman, 1993, is the prominent case. It's already been cited by 339 other cases. And some of them are sexual assaults, some of them are civil cases, and some of them are other types of crimes in criminal courts. You feel free, if you want to go through the database, the citation, the other cases that cited this case, to learn more. To learn more about the other types of cases and how this particular Supreme Court judgment gets used. So what I'm going to do is I'm going to copy paste this into the chat, so if you guys want to follow along, and of course for those of you who might be in your car driving listening along, I will go ahead and read this case. It's not, well, it's fairly wordy. I might skip some parts of it, but this case will prove how complex these types of situations are in our courts. It's not cut and paste. Oh, well, that's a recovered memory during a therapy session. Of course it's bullshit. Throw that out. No, our courts will take these claims seriously, and it's all just a matter of whether or not the lawyers make the right arguments and the judge uses the proper framework when coming to a decision. It doesn't matter if the evidence before them is bullshit. So, okay. So 1993, R versus Norman. This actually is not the Supreme Court judgment. Hold on a second. I have to find it. Is this... Wait, do I have the right case? Okay, this might not actually be Supreme Court decision. If there is another decision that came after this, I don't think there is, though. That's weird. You know what? Scrap that whole thing about Supreme Court of Canada, perhaps. I might be wrong. I might have missed that little detail. This might not actually have ever made it to the Supreme Court, this particular argument. So if that's true, and this is just at the high-level appeal court, okay, let's operate on that assumption, on that knowledge, that this is just Court of Appeal precedent. But it has been cited by 339 other documents. And yeah, like I said, as far as any Supreme Court judgments regarding this, they're very slim, if not any. There aren't any. So, all right. Appeal court decision for R versus Norman, 1993. I will fix the reference to this case in the video, in the stream, when I'm done the stream. Change the reference to appeal court from Supreme Court of Canada. All right. So, criminal law. These are just the basic Cole's notes of what the case is about. Criminal law, evidence, expert evidence. Complainant claiming to have remembered rape by accused 18 years later during therapy. Complainant's therapists testifying as to her memory recall process. Trial judge erring in taking evidence of therapists as corroborative of complainant's story. That's the error. Criminal law. Trial judge erring in determining credibility solely on basis of complainant's demeanor despite psychiatric evidence that persons in complaint's position often believe what they say regardless of whether or not it is true. Trial judge neglecting to examine reliability of complainant's testimony and in effect failing to give effect to presumption of innocence. Okay. The accused was charged with raping the complainant, then 13 years old, in 1973. The complainant alleged that she had forgotten the rape and remembered it in fragments in the course of therapy sessions. The Crown led expert evidence to describe the symptoms constituting child abuse accommodation syndrome in order to provide a psychiatric basis for the complainant's explanation for the lapse of time between the alleged offense and the laying of the information. Or laying of the information is another fancy term for saying filing a police report. Two therapists who treated the complainant also testified, describing the complainant's memory recall as fragmented initially and disclosing more details as the sessions went on. A psychiatrist testifying for the defense stated that, in his opinion, a memory suppressed by disassociation from post-traumatic stress disorder would not come back in fragment and be built up over time. He also stated that a therapeutically induced memory recall process may or may not elicit real memories of what actually occurred, and that, in either case, the patient is convinced of the truth of what he or she is recalling. The accused was able to establish that the color of the car he drove at the time of the alleged offense was different from that described by the complainant and a friend of hers who testified for the Crown. Further, he proved that he was not working at the co-op at the time or place where the complainant said he was, and she had testified that she recalled walking past him 5 days a week and that the accused had called out to her. Moreover, the complainant had not noticed that the accused's index finger was amputated and that the first and second joints of his next finger were permanently bent, despite the fact that she testified that the accused had large hands. Those injuries were the result of an accident that preceded the alleged offense. The trial judge made no findings with respect to these details and inconsistencies, and these aren't minor, these are pretty major. He found that the complainant was a credible witness and stated that the evidence of the two therapists corroborated her testimony. He ignored the testimony of a number of defense witnesses who gave evidence as to the accused's general reputation for integrity and his lack of disposition towards aggressive or violent conduct. The Crown asked the complainant in re-examination if she had heard rumors about the accused, and the complainant replied that she had heard that he had been dismissed from a job because of inappropriate sexual advances. This was a rumor that the complainant had earlier asked the police to investigate. She had received back a report that it was entirely unfounded. The trial judge overruled the defense objection to the question, ruling that the defense had put his character in issue. The accused was unable to remember many details about the occasion on which the offense was alleged to have committed, because it was a long time ago, and the trial judge described the accused's evidence as inconsistent and selective, and he was convicted and appealed. And here is the appeal. They overturned the conviction and order a new trial, which never happened. And I've explained in previous videos and previous live streams why that happens. So obviously the optimal the optimal outcome would be to allow the appeal, that is the language used, held, allow the appeal, held, and a new trial ordered. So the optimal result would be held, the appeal should be allowed, and acquittals entered, or convictions quashed and acquittals entered. That would be the optimal, that is the optimal appeal ruling. But instead he got the next one down, which is a new trial ordered, which means he has to start the whole process all over again from the point of, as if he was being charged again for the first time. And then go through the bail hearing and whether or not he did his sentencing already. He may or may not go to jail. But he would still have to go through the procedural process of having to hire a defense team and have them prepare for a new trial. But the Crown, they have the opportunity to either stay the charges or withdraw the charges. And we will never know unless you are intimate with the person involved in this case or the people involved in this case. You intimately know them. You work in the office, you work in the courts. What that outcome was, if the charges were stayed or withdrawn, because each of those outcomes have different repercussions for the man who's been accused. So moving on. All right, so now the appeal court is talking about the expert evidence aspect, which is very common, but it's becoming less and less common in these cases, possibly because of this ruling. This ruling basically, says that you can't use expert evidence to, corroborate a witness testimony if it's not relevant to the actual alleged crime. And really, courts avoid that nowadays. Courts will avoid bringing in expert witnesses whenever they can, unless it's involving some hard physical evidence, DNA or some sort of technology or something like that. But generally, try and avoid expert evidence, and judges don't really like it when you bring in experts. But the other thing too is if both sides bring an expert, one side brings in an expert and the other side brings in an expert to refute the other side, then you've just negated the whole purpose of bringing in expert evidence. Now you just have two conflicting expert evidence testimony, which is the whole reason why you're there in the first place. So it's a waste of everybody's time and money. It doesn't really help the facts of the case, doesn't prove any facts of the case, and the judge or the jury can still just be as confused and misled as ever. So, but this is in 1993, so they're talking about expert evidence being of considerable value in cases such as this. The trier of fact is unlikely to be familiar with such phenomena as child abuse accommodation syndrome. You might want to take note of that phrase and do some research on that if you are at all curious about it. Child abuse accommodation syndrome. However, the knowledge that a psychiatric condition exists that could be responsible for the complainant's lack of memory does not relieve the trier of fact of the responsibility to satisfy himself whether the accused committed the alleged offense. Let me just back up a little bit there. Child abuse accommodation syndrome was commonly used in the 80s and 90s, probably developed and coined during that period, as a way to explain away why kids have a delayed recall or a delayed period of time in reporting alleged abuse to the police, or why it only came out later on in time after a parent's going through a custody battle and somebody's claiming that the kid was abused by the other parent, but the kid never said anything until they were later interviewed because they were accommodating their loved ones. That's basically what this whole thing is for. It's basically just a legal term to help explain away a delay, really, or the love for that parent that allegedly abused them. The kid still loves that parent even though they allegedly abused them because they're accommodating them. So anyway, that's pseudoscience if you ask me. But back in 1993, it was considered of value. So again, I'll just go back here. However, the knowledge that a psychiatric condition exists that could be responsible for the complainant's lack of memory does not relieve the trier of fact of the responsibility to satisfy himself whether the accused committed the alleged offense. Okay, so he's just saying that even so, this convincing, helpful, probative expert evidence can help us understand some things, it still can't prove that the accused committed the offense. The expert evidence in this case was neutral so far as the fact-finding process was concerned. The trial judge apparently treated the evidence of the therapists as corroborative of the validity of the memories recalled. Alternatively, he may have regarded the statements to the therapists as corroborative in the sense that they were prior consistent statements. Either treatment of the evidence was erroneous. So that was the error in law that triggered this case. It has nothing to do, they're not actually arguing the repressed memory or the recovered memory and whether or not it should be in court. All they're doing in this appeal case is arguing the fact that because you had one or two therapists basically say, oh yeah, this can happen and that can happen, and that's, repressed memories are signs of this and signs of that, and they're believable and you should believe them, blah, blah, blah. You can't use that as corroborating evidence that a claim is true. But the judge in this case did, and that was his error. Moreover, the trial judge failed to appreciate that a significant feature of the therapist's testimony was that it described a recall process which did not conform to a real memory disclosure as described by either the Crown or defense psychiatric witness. Lastly, the trial judge effectively disregarded the defense expert evidence by relying upon an improper question put by the Crown in cross-examination, asking whether the expert's opinion would have been affected if there had been an independent witness to the sexual assault. The question by the Crown to the complainant about rumors she may have heard was improper, and effect should have been given to the defense objection. As the expert evidence adduced in this trial indicated, the appearance of honesty and integrity on the part of witnesses such as the complainant is of little assistance in assessing the credibility of their testimony, since these witnesses believe in what they are saying, whether it is accurate or not. This insight was apparently lost on the trial judge. And that type of insight still is lost on trial judges to this day, unfortunately, even in cases where they don't bring in expert witnesses to, bolster the validity of repressed memory or forgotten memories or delayed memories. So, the trial judge failed to give effect to the presumption of innocence. He described the accused's inability to recall the minutiae of the occasion on which the offense allegedly occurred as selective recall, while excusing the complainant's inconsistencies as insignificant when related to the charge. Thus, he effectively shifted the onus onto the accused to prove his innocence. And we still see a lot of this today. Regarding selective recall, it's broken down more further in this decision, but they're referring to the Crown making the claim or the assertion that because he denied certain things but did have certain memory recall of certain relevant incidences, that he was exercising selective recall because he had a motive to hide or a motive to not recall the crime, because that would mean he would be convicted and sentenced harshly. Like, that's just, crowns shouldn't even be allowed to do that, but they did it here, and I still see it in current modern day decisions, court decisions, and even judicial decisions that never get overturned. It's terrible that judges and crowns play that game, when they have nothing else to go on. So, the trial judge apparently determined credibility solely on the basis of the demeanor of the complainant and a friend of hers who testified for the Crown. An assessment of credibility based on demeanor alone is not good enough in a case where there are so many significant inconsistencies. The demeanor and credibility of the complainant are not the only issues. The reliability of the evidence is what is paramount. The evidence in this case should have been subjected to more careful scrutiny than it received. The trial judge wrongly failed to consider evidence which bore directly on the issue of guilt or evidence. All right, so that's just more... the scrutiny issue is a major one, and this is also a very common ground of appeal for people in he said, she said, or she said, he said cases where there was no hard evidence that any crime occurred, and a judge convicts anyway, or a judge convicts, and they have to weigh both sides of the evidence. And a common appeal ground that comes out of that is that the judge did not exercise the same level of scrutiny on the complainant's problems with their testimony that they did with the accused. Very common. It's simple. That's how judges convict, is they get away with saying, I'm aware that I have to, carefully balance and weigh credibility, because credibility is all that's at stake, and this whole case turns on credibility and reliability, and I'm aware of that. But then they go and spend, one paragraph assessing the credibility of the complainant as, well, she believes everything that happened, and I believe her, and her demeanor showed that she was a victim of a terrible crime. So yeah, she was a believable witness. She's credible. Moving on to the accused, and then we'll write 3 pages of why they're rejecting the accused's evidence. And those don't always get overturned in appeal cases, because sometimes that's the only basis of which you can appeal, is complaining about the scrutiny, and that's another area of deference that appeal courts don't like to mess with. So yeah, it's just really, I'm not here to cheerlead for the law and say that go rule of law. People really need to pay attention to the rule of law. But if you read these cases, you'll see that there is no rule of law when it comes to our courts. It's, what is the rule of law? What does it apply to? Where, like, you know, at what process of the justice system are we talking about? Because apparently each procedural process of the justice system has its own rule of law or set of rules and laws applicable to that stage. So like police services, for example, they have their own policies and their own rules that they have to abide by. And they can develop those policies on their own, and they're not even bound by law to follow them. Same with the crowns and the prosecutors. They're not bound by any law to follow them. And then you have defense attorneys. Well, that's a whole other story. They are bound by a lot of rules and laws. And crowns have the entire power of the state and a regular steady paycheck. They have all that power behind them to sit there and study defense attacks and mechanisms and make sure that any defense lawyer that they don't like gets disbarred. And then judges, like, you know, they also are an independent body, apparently, who also have their own set of rules, laws, and ethics that they go by. And then the Supreme Court of Canada, basically, they look at anything, and any appeal court and Supreme Court of Canada just want to know, was there an error made in wordplay? Wordplay. What words were used in the framework of this decision? Did they do anything wrong as far as stringing together a bunch of words? Did they apply a particular legal mechanism properly or improperly? That's all we care about. We don't care about whether or not there's a possibility that an innocent person may have actually been convicted and have their complete life completely destroyed, and the whole family along with it. No. That's not what we're here to discuss. We're here to discuss if an actual mechanism of the law was improperly applied, or if the wrong, incorrect legal words, terms were strung together in a particular decision. That's all we care about. So, you know, what the hell does rule of law mean and due process mean, really? You know, when you read these types of verdicts over and over and over again, you can't help but ask that question. So, anyway, so let me go on. But before I do, so the trial judge wrongly failed to consider evidence which bore directly on the issue of guilt or innocence. And then goes on to cite a whole paragraph filled with other cases. Some of them Supreme Court, some of them just appeal court, and some of them just trial level. So, you know, in your spare time, if you want to click through them and read how they're relevant to this case, feel free. So, this basically was a preface to this whole appeal court decision, but it goes on to talk about the facts of the case. So David L. Norman appeals his conviction on July 23rd, 1992, of having sexual intercourse with X, a female person who was not his wife, without her consent, contrary to Section 144 of the Criminal Code. The offense is alleged to have taken place in September 1973, when the appellant was 28 years of age and the complainant was 13 years old. The matter went to trial in the spring of 1992, over 18 years after the events in question transpired, allegedly. The complainant, X, and George Coggins, a witness in this case, belonged to the Waterford Baptist Church. The appellant belonged to the Villanova Baptist Church. The appellant and Coggins were adult leaders for the area's Baptist youth groups. Each church had its own group, and from time to time they would get together for joint events. A corn roast at Hay Creek Conservation Area on September 8th, 1973 was such an occasion. It is here that the rape, as such it was in 1973, is said to have occurred. The following is an analysis of the evidence. So before I go on, because this was alleged to have occurred in 1973, that was before we removed rape from the criminal code and replaced it with sexual assault and in other things. So they're going on the actual provisions that existed in the criminal code at that time, which was rape. And this is also known as the corn roast case. So I do believe there was actually a Supreme Court case that followed up after this. So I might be a little one step behind in this, but nonetheless, this is the aspect, the stage in the case where it discusses the therapy-induced memories, which is what you guys want to know about. So, evidence of the complainant. The complainant testified that she went to the corn roast in Coggin's car with Karen Thompson, an older member of her church's youth group, and Brenda Goebel, a close friend and neighbor who did not regularly attend either Baptist church. The complainant testified that once they had arrived at the picnic site, the appellant asked her if she wanted to come with him to his car to get corn for the roast, and the car was some 300 feet away. She said she remembered feeling honored and proud to be asked, and so she went with him. As they were talking, she put her arm through his and was kind of dancing around, being silly and just talking. When they reached the car, the appellant told her he had something to show her and guided her through the car park to some bushes. She stopped and asked him what he was going to show her. He pulled her into the bush. While she struggled and tried to break free, he took off his belt, whipped it around her waist, and flipped his wrist to make her fall. The complainant then described a violent sexual assault in which she was forced to perform fellatio and was raped. She testified that she took her head back and forth and said no to the fellatio, but the appellant replied, "You want it, you sexy bitch." When he forced his penis inside of her, she again said no, and he laughed and said yes. She said the appellant put his hands around her throat to prevent an outcry, threatened to kill her if she did not stop trying to shout, and punched her in the side of the head, knocking her unconscious. When the complainant regained consciousness, it was darker. She returned to the area of the campsite. She went into the bathroom, an outhouse, I believe, and sat on the floor crying. People came to the bathroom and asked if she was okay. She told them to take off. After some time, the complainant left the bathroom and approached her friend Brenda, who was sitting by herself away from the group. She asked Brenda if her mascara was smeared. Brenda replied that she looked fine and asked if she was all right. Although the complainant was not certain at trial, she thought she also remembered Coggins asking her if she was all right later on in the evening. She was certain, however, that she expressed to him a desire to go home. As a result, she, Brenda, and Coggins left the corn roast earlier. The complainant told no one but Brenda about what had occurred, but even this was only a passing reference. While walking to school soon after the incident, the complainant said to Mrs. Goebel that she did not want to take their normal route because it took them past where she said she was the appellant's place of employment. Mrs. Goebel testified that she responded to this by asking, "So?" And the complainant replied, "Well, that's the guy that raped me." In October of 1987, the complainant began counseling for childhood sexual abuse, which appears on a limited record to be unrelated to the sexual assault in issue here. So either she was a victim of previous actual sexual assault, or she has a history of fantasizing that she was a victim of sexual assault when she never really was. According to her best friend Goebel, this childhood abuse involved many persons, including the complainant's great-uncle, her uncle, and her grandfather. The complainant testified that through counseling she was able to recall memories of both the incident with the appellant and the earlier abuses that she had suffered. These memories, she said, had been completely blocked from her mind until she entered therapy in 1987. Over the course of her counseling, she experienced a number of memory flashbacks with respect to these events. There was expert evidence at trial concerning this self-induced memory blockage, which is now called by some psychologists child abuse accommodation syndrome. Interesting. I'm pretty sure we don't see this in any modern day cases anymore. So apparently this child abuse accommodation syndrome didn't really last long in the courts. Again, if you want to do research on this and help me out, because I could as well, but I don't have a lot of time to go out of that fray. But it's very interesting. What else can I say? All right. So Before entering therapy, the complainant had no memory of the rape she later alleged David Norman to have committed. She knew only that seeing the appellant Norman aroused in her great fear. She recalled that she and the appellant had been together at the corn roast, and she could remember that she went with the appellant to get corn, but she could not recall what occurred after that until she underwent therapy treatment. After approximately 100 treatments, the complainant's recollection of the alleged rape gradually returned. The recollection included details of what the appellant had been wearing: a belt made of gold and silver with an unusual design, a brown plaid shirt, brown work pants with a good crease, and dark boots with a zipper on the side. She also recalled that he had freckles or a rash on the shaft of his penis. In October 1998, after regaining some memory of her alleged assault at the hands of the appellant, and after determining the date of the corn roast by calling Reverend Hahn, a Baptist minister who had been present at the event, the complainant went to the Waterford police. She asked the police not to lay charges immediately, however, because she was involved in another sexual abuse case against her uncle. She did not feel that she could handle two cases at the same time. Okay, so this is very interesting because this case, it's laying bare that she was busy, processing all of these memories and accusing people, her uncle, her father, her grandfather, this dude at the corn roast, all kinds of people, accusing them of rape and taking them to court, whether it's criminal or civil, I don't know. In this case, it's criminal, but the other cases, I don't know. But anyway, she's doing this all of as a result of her therapy sessions, but it's laid bare here in this decision. Now, what's changed in today's trials that I've noticed is that crowns and defense attorneys will leave that stuff out. Police will not even investigate whether or not the accuser is involved in any other cases. If they happen to stumble across that information, they won't divulge it because they don't have to. They leave it up to the courts to figure that out, or the defendant to figure it out. And then they're up against all of these rape shield laws, preventing them from accessing that evidence and deducing that evidence to submit it as evidence in their favor. Or at least to cast a doubt on the whole context of the complainant's motive and story, as this case does very well. During the period following the recovery of her memory about her various sexual abuses, the complainant became active in a child sexual assault survivors group and was interviewed by various newspapers and other media. Now, that's something that has not changed. It still happens today. It's still happening. In early October of 1989, she accosted the appellant and his wife at a fair and said to Mrs. Norman, "Did David ever tell you that he raped me on September 24th, 1973 at a corn roast?" In a letter to Mrs. Norman, dated October 10th, 1989, the complainant repeated the allegation of rape and expressed concern that the appellant might be committing incest with his daughters. Okay, now we have entered hysteria territory here. She also asked the police to investigate whether the appellant had been fired from his employment for improper behavior, and she said, heard rumors to this effect. On April 16th, 1990, her parents wrote to the appellant demanding that he resign from the office of vice president of the 4-H Leaders Association because they had been aware of his crime for some time now, and finding you in this position of trust where similar incidents could occur causes us great distress. A lawyer for the appellant informed X's parents that they should stop harassing the appellant or he would face a civil suit. Or they would face a civil suit. According to police notes, the complainant asked that charges be laid on May 5th, 1990. These notes also make reference to a letter from the appellant's lawyer to the complainant's parents. At some point in this narrative, the uncle, whose sexual abuse case she had accorded priority, died. That's really sad. Evidence of Brenda Goebel. Brenda Goebel was described by the Crown as an independent witness, and she was scarcely that. She had been, since grade 5, the best friend of the complainant. Their relationship was described by the complainant as sisterly. Further, the manner in which Miss Goebel's memory was recalled should have caused her testimony to be subjected to the closest of scrutiny. She had been with the complainant on the night of the alleged rape, but she could recall nothing about the evening until she was reminded of it in 1988. Sometime in that year, the complainant asked Mrs. Goebel in a telephone conversation if she remembered the corn roast. When she replied that she did not, the complainant said, "Oh, sure you do. You were there with me. That was the corn roast that I was raped at. Remember?" Sorry, but I mean... According to Mrs. Goebel, at that point, she had a flashback or memory of the complainant coming out of the bush, and she said, "You know, you're right. I do remember." The complainant told her to write down what she remembered. Mrs. Goebel later told the police that she had a memory of the complainant coming out of the bush, but that she could not recall seeing the rape itself. Oh my God. If somebody was actually friggin' raped, you're going to remember it. I'm sorry, but... Anyway, sometime later in 1988, at Mrs. Goebel's request, the two friends went to the conservation area to see if their joint observations would trigger some further memory. Apparently, it did not in the case of Mrs. Goebel. Yeah. However, she had another memory flashback subsequently when she received a Christmas card from a mutual friend of hers and the complainant's. On the basis of this flashback, she recalled far more of the events of 1973 that she had hitherto. In addition to the information set out in her police statement, Mrs. Goebel now remembered that she had gone looking for the complainant after being told that she and the appellant were fucking. She followed a path in the bush, pushed aside some limbs, and saw the complainant lying on her back with the appellant on top of her. They appeared to be having intercourse. She was stunned and returned to the picnic table. Later, the appellant arrived at the campsite with the corn. In Mrs. Goebel's words, he seemed very happy, laughing as if someone had told him a good joke. God. There is nothing on the record which explains why Mrs. Goebel would be subject to the same memory blockage and recall process as the much abused complainant. Mrs. Goebel explained, without elaboration, that she came from a dysfunctional family. No other explanation was offered for her having forgotten what she saw her friend do or say that evening. She can't use the child abuse accommodation syndrome that this other chick is using. Not gonna work. So, this is so ridiculous as I read this. My God. Anyway... Crown Counsel made an attempt in this court to relate Mrs. Goebel's flashbacks to child abuse accommodation syndrome. Oh my God, the Crown actually tried it. What the fuck? But there was no expert testimony to this effect at trial. I will deal with this disorder later when I touch on the expert evidence. In my view, however, it trivializes post-traumatic stress disorder to say, as the Crown did on appeal, that Mrs. Goebel suffered from a form of this syndrome as a result of her friend's experience. Jesus Christ. Another aspect of Mrs. Goebel's memory recall concerns me. The complainant insisted at trial that she had no memory of the content of her first telephone conversation with Mrs. Goebel in 1998, and the conversation that provoked Mrs. Goebel's first flashback. Gotcha. Indeed, the complainant appeared anxious to distance herself from Mrs. Goebel's memory recall process, stressing that on their revisiting the scene of the alleged rape, they were careful not to influence each other's memories. However, notwithstanding these precautions, as counsel for the appellant pointed out, there were remarkable similarities in their evidence. It concerns me that these similarities often arose when the particulars were wrong or at least seriously in dispute. Oh, quick, I need corroborative backup. Oh, quick. Yeah. It's not, no. Thank God this appeal court caught all of this. I note, for example, that the erroneous testimony of both of these witnesses concerning the color of the appellant's car and the location of his place of employment. This testimony suggests collaboration in the development of the memory process. So, just want to say, this case here is brilliant. It really tore apart. I mean, it should never have made it to court, obviously, but it tore apart everything that's wrong with false accusers and recovered memory therapies, coming out with memories, and then trying to get people to back up your memory recall and your experience and pretend to be a witness and all of that. But it also explains why in today's cases, how crowns have figured out how to get around all of this so that they can still run these cases through the courts. So basically, you're not going to have an expert witness, and you're not going to call any witnesses, basically, unless they were, indisputably there and witness to some aspect of the event of the night. So it's interesting to see how cases have evolved from this to where they are today, and that is just, get rid of any possible scenario, cut it from the case that could potentially destroy our case, our prosecution, and show it for what it really is, a farce. And just leave it to a dumb judge, because there's lots of them out there, or a dumb jury, or an easily, a jury that we can manipulate. Leave it to them to base their decision based on the least minimal amount of evidence we can put in front of them to come to a conviction. And 50% of the time, it works. So evidence of a neutral witness, Karen Thompson, she testified to having grown up in the Waterford area. You know what? I'm going to skip the neutral witness because that's exactly what it is. It's neutral, means nothing, doesn't take away or give to the case. It has nothing to do with it. Okay, let's see. Who is this person? Karen Thompson. All right. Reverends, yada yada, other witnesses. I know when we came back to the circle. Okay, I had grass in my hair, whatever. Let's see. I want to get away from these witnesses because they really don't do anything. Let me just go straight to the evidence of the appellant. Okay. So the appellant testified and denied any sexual contact with the complainant. His memory of what did take place was understandably vague. He was not, after all, accused of any impropriety until sometime 15 years later after a corn roast he went to. He attempted to prove factually what was provable, but in the final analysis, he relied upon a categorical denial. The sum of the collective remembrances of the other witnesses at the corn roast was that nothing happened to remember. So, again, this is typical. In these cases, the dude has nothing else to say, but you know what? I don't remember what happened then, but I'm pretty sure that didn't happen. In fact, I can confidently, categorically deny it didn't happen. But if you want to try and ask me some very specific details about that 15 years ago, I'm not going to be a very good witness. I'm not going to have a lot to say. Which, the Crown loves that. They will just rip that apart like a pit bull. Oh yeah. So, okay. The appellant recalled attending the corn roast. He remembers it. He testified that when he went to his car to get supplies, he was accompanied by a girl whom he had not known previously. She was flirtatious, he recalled, and sat on the trunk of his car as he was trying to open it. After repeated requests, she removed herself, and the appellant got the supplies, and they both returned to the fireside. Some days later, he ran into the girl, and recognizing her from the corn roast, they briefly spoke. He denied all contact with the girl apart from these two occasions. Furthermore, he stated that he did not work at the Alice Saint outlet of the co-op. Small point, but that's a pretty big deal. You want to get those facts right if you're going to make a complaint about somebody. So the appellant denied that he even owned, much less wore, to the corn roast the clothing that the complaint alleged he was wearing. The belt that she described at trial was particularly distinctive. In her initial statement to the police, she made no mention of the belt or the use made of it in throwing her to the ground. Her explanation was that she did not have then a complete memory of the event. The appellant also said, okay, hold on. Her explanation was at the time when she gave her police statement, she did not have a complete memory of the event. It developed more by the time she got to trial. And that is as a result of going to these therapy sessions and being guided into creating and developing this entire narrative of a rape that never occurred. Now that still happens today. It's just that you're very, very lucky as an appellant or a defendant if you are able to even have all of that stuff brought up and put on the record or admitted as evidence, or question, if you're allowed to even question the accuser about her therapy sessions. You're not even allowed to do that. The cops aren't allowed to do that. Nobody's allowed to do that without a private record production application hearing, which costs a lot of money, extra money for the defendant, but also a lot of the times the defendant won't even know to think of that because they haven't ever spent time with this person, or they haven't seen them in 15 years. They've never met them before. How do they know that they're going through therapy? The only reason they would know that is if it was said on the public record, in a police record, in a statement to the police that they have access to, or to a Crown in a meeting. And they've gotten around it nowadays. They're avoiding that by police being instructed not to ask questions about seeing a therapist, not to ask questions about previous therapy or memory recall or anything like that. Just to let the complainant tell the story and get it on record, and that's that. Leave it at that. However, we still do have situations where the police statement that the complainant gives will be vastly different than the testimony at the trial. We still have this problem. And oftentimes the Crown and the judge will explain it away as not necessarily recovered memory therapy, but needing more time to be given the tools to help reconstruct the trauma that they endured that led them to where they are now. It's just repackaged, but the same shit happens. Anyway, so the appellant also said that the car he drove at the time was red, and he produced a picture of it along with the registration of the year 1973, which contradicts the complainant's story, who recalled that the car was a brownish color with gold or greenish metal flake, and Mrs. Goebel, who said it was a light greenish color. Yeah, doesn't that sound like Mr. Giangomesci's case, the yellow bug that he didn't even own at the time of the alleged assault? Same here, but yet the judge convicted the dude. He also denied ever having freckles or a rash on his penis. How insulting would that be? My God. This latter piece of evidence takes on greater significance when the defense psychiatrist testified that the complainant's memory recall of such a condition on the appellant's penis was bizarre. It was one of the reasons he gave for doubting the accuracy of her memory. Finally, the appellant showed that the court that his index finger was amputated and that the first and second joint of his next finger was permanently bent. This disfigurement was not noticed by the complainant, notwithstanding that she testified that he had large hands. The appellant and his doctor testified that the injuries were the result of an accident that preceded the alleged rape. The trial judge made no findings with respect to these significant details and inconsistencies. Indeed, he did not even refer to them. And to think we have a whole new generation of judges like this on our panels, on our benches. The trial judge did not even give any reasons for disbelieving the appellant, although he must have done so in order to convict. He limited his remarks to saying that the appellant's evidence was inconsistent and later that it was selective. All right, so again, this is something that has changed in today's trials. judicial decisions, the trial judge will just disbelieve the appellant who just says nothing but a blanket denial that never happened, did not happen. And the judge is allowed to disbelieve them. But he has to give reasons or write down, string together, construct sentences and paragraphs on a piece of paper that explain why he's disbelieving him. And he has to do it in certain, all you have to do is cite REM, R versus REM, which basically says, I do not need to give any other reasons why I'm rejecting his evidence other than the fact that it conflicts with that of the complainants, of which I accept. So that saves them now. So that allows a judge to convict an innocent person. So his examples of inconsistency and selectivity are unfortunate. He said that the appellant could not recall the specific corn roast. Well, apparently they happen annually, but he, couldn't recall the specific one, maybe. Actually, the appellant testified that he did remember the corn roast. Oh, well, what do you know? Again, another case of the judge not reading the transcripts. It was the only one held at the Hay Creek Conservative Authority. So there you go. It was the year he had trouble remembering. It was the year that it occurred that he had trouble remembering, which is very different than saying, I don't remember ever attending a corn roast. That is very different. Anyway, the trial judge understood the appellant to have testified that he did not know what supplies he took to the corn roast. This, said the trial judge, was troubling because it had been the appellant, according to Reverend Hond, who suggested a corn roast due to his good crop of corn. The appellant did not grow corn, and he never said that he did not bring corn to the roast. He simply said he could not remember if he brought it on this occasion. Okay, so now we get to the expert testimony. The Crown elected to introduce its case by calling a psychiatrist, Dr. Pickering, to describe an aggregate of symptoms constituting what is now known as child abuse accommodation syndrome. The expert testimony provided a psychiatric basis for the complainant's explanation for the lapse of time between the alleged offense and the laying of the information. Again, charging. This testimony also explained the role therapy can play in the retrieval of the memory. These are proper uses of expert evidence. In a recent decision on the Supreme Court of Canada, R versus Marquard, now reported, for the majority of the court, blah, blah, blah. They say, there may be features of a witness's evidence which go beyond the ability of a layperson to understand, and hence which may justify expert evidence. This is particularly the case in the evidence of children. For example, the ordinary inference from failure to complain promptly about a sexual assault might be that the story is fabricated, afterthought, born of malice, or some other calculated stratagem. Expert evidence has been properly led to explain the reasons why young victims of sexual abuse often do not complain immediately. Such evidence is helpful, indeed it may be essential to a just verdict. For this reason, there is a growing consensus that while expert evidence on the ultimate credibility of a witness is not admissible, expert evidence on human conduct and the psychological and physical factors which may lead to certain behavior relevant to credibility is admissible, provided the testimony goes beyond the ordinary experience of the trier of fact. Okay, so again, it's basically leaving it up, the judge and the jury have full discretion to decide using their common sense, whether a memory is false, contrived, true, whatever. But if there's a certain aspect of the development of that memory that requires extra explanation by an expert, then that's allowed. However, the appeal court has a serious concern that the expert testimony in this case on appeal was not restricted to this purpose. The Crown at trial and the trial judge appear to have treated the Crown's psychiatric testimony, and particularly the evidence of the two therapists, as corroborative of the validity of the memories recalled by the complainant through the counseling process. So, we already know that the judge erred there. And then it Goes on to refer from another case, from that Marquard case, talking about witness expert evidence, blah, blah, blah. I'm not going to read all of that. Okay. So that's... Okay, so Dr. Margaret Ruth Pickering, which was one of the expert witnesses, who was accepted by the defense as an expert in child psychiatry and child sexual abuse, testified to the condition known as child abuse accommodation syndrome, which is a variant of a larger category of psychiatric illness known as post-traumatic stress disorder. A victim of this syndrome would put an experience such as the alleged rape out of her mind, Dr. Pickering said, and it can be literally decades before that memory is restored through a series of flashbacks. These flashbacks frequently occur during therapy when the patient, addressing issues from her past, begins to access memories that have been closed off. These disassociated memories come back in bits and pieces, with some early flashbacks being tiny little discrete bits, yet nonetheless accompanied by powerful and vivid feelings and images. As the trial judge noted, Dr. Pickering's evidence was that the validity of a memory recall can be attested by the intensity of the images at the time the person is experiencing the memory flashback and the consistency of the detail. Alright, so that's how repressed or recovered memory is described in our court at this time. They relate it to PTSD and child abuse accommodation syndrome, which I'm pretty sure that has been debunked, but if you do research on that, you'll find that out. The courts no longer rely on this particular diagnosis as anything reliable. As to how that came about, that's a difficult one to find. Good luck. I do remember searching for it years back, and I couldn't pinpoint what caused it. I remember finding a case that said it is no longer valid in the courts. It's no longer accepted. But how that came to be, I don't know. Now, if you are working on a case, or you have a case, or you know of a case where this case is relevant, you should also know about another case, which I will have to highlight at some point. It's a Supreme Court decision, for a fact. I think it's R versus Trochem. If I recall correctly, it's Trocym. I'm going off the top of my head. It might be a different case, but nonetheless, it is the only Supreme Court of Canada case that deals with evidence given or statements, witness statements made after hypnosis. Okay? The Supreme Court ruled that is basically illegal. You cannot be a witness if you're going to give a statement that comes from a hypnosis session. That is not reliable. End of story. So our courts know this. Everybody that works in the courts know this. Well, hopefully. So what they've done to get around it is give different things terms, new terms. So anything that comes out of therapy sessions that we now have sex shield, rape shield laws to deter anybody from questioning a complainant's therapy history or bringing it in as evidence. Since nobody has to ask that question, people don't know that complainant's been dealing with therapy. So we don't know to ask the question, what kind of therapy did you have? Was there any hypnosis involved in this at all? Now, one would have to imagine, of course there's a level of hypnosis, but what kind of hypnosis? What kind of regressive therapy techniques are being used to generate these terrible flashbacks? Like, what a terrible thing this is to do to people. But regardless, what can be considered or categorized under the umbrella of hypnosis, hypnotic therapies? That is the question that the Supreme Court has never dealt with. So until that's ever been dealt with, we can still use the substance or the basis of how these memories come about and just reword them, repackage it to make it not sound like hypnosis was ever involved. But in this particular case, you can sort of gather that vivid feelings and images accompanying little flashbacks, dissociative bits and pieces of memory, like, that doesn't just happen while you're doing laundry, in the context of doing therapy sessions. This must be happening during therapy sessions. Wouldn't we like to know exactly what's bringing those about? Well, in Canada, we're not allowed to ask, and we're not allowed to bring that on the record. So until then, it is left up to a judge or a jury to decide if those vivid feelings and images, little discrete bits, disassociated memories, bits and pieces, and flashbacks are born from actual experiences or not. So the next therapist who they brought on treated the complainant. She is a clinical coordinator of an inpatient unit at St. Joseph's General Hospital at North Bay and has a degree in sociology and psychology from Wilfrid Laurier University. Ms. Elkin first met the complainant at the Nova Vita Women's Shelter in Brantford when the complainant sought advice and counseling after listening to a radio program on sexual abuse. Following this initial contact, Ms. Elkin was involved in approximately 63 individual and 18 group therapy sessions with the complainant. Her evidence was very brief. When asked about the manner of the complainant's memory recall, she responded in full. Fragmented initially, and memory became clearer over a time with memory sessions. Dorothy McClellan was the other therapist. She has a BA in psychology and social work from McMaster University and a Master of Social Work from the University of Toronto. She gave the complainant individual counseling. In her testimony, Ms. McClellan described the complainant's memory recall process. During the initial disclosure of the rape, she said that the complainant was muted in terms of not showing a lot of affect, and that's very, very common for incest survivors who are disclosing for the first time, especially in a group situation. Later, the complainant disclosed more details and disclosed more emotion. Well, isn't that interesting? So this particular therapist is basically saying at the beginning of these sessions, she said nothing. But later, as she became, influenced by all these other alleged survivors and other psychologists and counselors and therapists, she began putting together her narrative. Well, obviously, because she's also probably being told how, she can get compensation from the government if she puts together a damn good convincing story. And she can heal. She can finally heal from all of her life's problems if she finally admits that this happened to her. Bullshit. Anyway, so the trial judge accepted the written submissions of the Crown that the evidence of these two therapists corroborated the testimony of the complainant. So if she said it, then it must be true. I mention the source of the word corroborated because Crown Counsel on appeal suggested that the use of this word by the trial judge was inadvertent and of no significance. Wow. Luckily, the appeal court here does not accept this explanation. I think it is clear from the reasons of the trial judge that he accepted the submissions of the Crown at the trial that the testimony of the two therapists in the context of the evidence of Dr. Pickering was corroborative of the complainant's evidence. What is unfortunate is that he did not specify in what regard it was corroborative. This evidence certainly supports the fact that the complainant underwent therapy and experienced a recall process, but these matters were not in dispute. Because of the brevity of the trial judge's reasons, I am left with a concern that he treated this evidence as corroborative of the validity of the memories recalled, notwithstanding his earlier ruling that his evidence could not be used for oath helping. Alternatively, he may have regarded the statements to the therapists as corroborative in the sense that they were prior consistent statements. They were not, however, admissible for that purpose. That is also illegal. Thus, under either interpretation, the trial judge's treatment of this evidence is very troubling. So it goes on to say that the trial judge's approach to the issue of credibility solely relies on his impression of the complainant and virtually took no analysis of her evidence. That's also how you wrongly convict somebody. And it goes on and talking more about the corroboration issue. Goes on more about sexual abuse accommodation syndrome. Was not a recognized psychiatric disorder, but did confirm much of what Dr. Pickering said. So these are all these psychologists just throwing around, making up words and coming up with scenarios just to justify their tinkering with the brains of people who, they know they can have for 100 sessions money in their pocket. And by the end of it, they don't care whether or not their memories are real or not, because it has no bearing on their profession, none whatsoever. But, the problem is therapists, psychiatrists, counselors, if any of you are watching this, you must know that it has huge bearing on an innocent person's life as soon as such an accusation is made. Especially now that you, as a therapist, psychiatrist, psychologist, whatever, you are also considered a mandatory reporter. And if you have this repressed memory come about in your office and a person is named in your office, and this alleged therapy or abuse happened when this person was a child, or this person has a propensity, alleged propensity to have a sexual interest in children, you as a mandatory reporter must immediately call the police and report that to the police. And people do that. And they are coached to do that. They are coached to do that. So, what the hell are you guys doing as a profession here? If you are a decent psychologist, psychiatrist, or therapist, counselor, whatever, if you have any heart, if you have any ethics, if you have any, moral fiber, principles, you would actually do something and stand up for your profession to make sure that this crap is cut out and no longer allowed, or that anybody who stands by that concept of inducing bullshit memories through regressive hypnotic type therapies, you should denounce that, really, is all I have to say about that. You must denounce it. Report it, denounce it, write about it, blog about it, do something. All I can do right now is point out cases that use this. So let me just see if I can get... I think I've pretty much covered the meat of the recovered memory aspect of it. It just goes on and on. There's just so much to this case. It's become so complex, when really it shouldn't be, but that's the joy of case law. But ultimately, the man was, he had his conviction overturned, and he won his appeal. And this case gets cited by 339 other cases. And there could be more that we don't see that aren't in the database. But, all right, I'm going to take a break here and go to the chat live here. I'm going to pull this up, pop out. Okay. Whoops. Pop out. Hey, guys. Black Knight Fool, good to see you again. I haven't seen you here in a while. David McLean, hello. Fillerator, okay. You guys still with me? David McLean, defense attorneys routinely accept contracts from the Crown, which supplements their income. That's disheartening. Really? There are also unwritten laws. Defense attorneys should not question the victim too minutely, because it might piss off the judge. Yeah, well, we know this, yeah. I've seen that a lot. I believe that, yes. In fact, a case very close to me, in my partner's case, yeah, that happened. The defense even, actually, there was actually a moment in the trial where his defense attorney actually stood up and objected in favor of the alleged victim when the Crown attorney was questioning the complainant. The defense attorney actually got up and said, that question's already been asked. The Crown should not be asking this question to the victim. And I read this in the transcript, and I'm just like, what the fuck? No, that's not how you defend your client who maintains very steadfastly their innocence by standing up for the alleged victim against the Crown. No. That's not how it works. Just terrible. But that guy, I've seen that attorney do online interviews and write, be interviewed for media inquiries and whatnot regarding sex assault cases, and he takes a very neutral view. And it's very disheartening. Many, many defense attorneys are trained to do this. And as you say, maybe they have deals, with the judge or the Crown, whatever. Anyway, David McLean, as mentioned above, the stress of PTSD can have severe effects on the hippocampus, causing problems with transferring short-term to long-term memory. Well, sure it can, but if you, survived a plane crash or a car crash or a severe blow to the head, multiple concussions in, boxing rings or hockey rinks, sure, I believe that. But, just by having someone's penis inserted in you, no. I'm sorry, but you're not going to get that kind of PTSD. There's no evidence of that. There's no proof of that whatsoever. Now, if you were brutally attacked as you were jogging and running along in the bushes, and, suddenly some man comes at you with a knife and slams you to the ground, I could imagine a blackout moment there, sure. But in any of these other bullshit cases, no, I'm sorry. So Wilfrid Laurier University, where we heard that before. Yeah, I know. Yeah, the arbiter of, I don't know what, the arbiters of what, you fill in the blanks. David McLean, as an ex-soldier, I have dealt with friends who have had PTSD. Some would beg for the memories to go away. See, you would know, of course. Yeah, that type of flashback where your brain is actually truly malfunctioning. There's a circuitry in there that's malfunctioning. For some reason, it just doesn't want to let go of that extreme memory. You just have to relive it over and over again. I can imagine. I was in a car accident. Yeah, I can even use my own experience. I was in a car accident once many years ago. I was 15. And I'm in my 40s now, so this was a long time ago. And I can still remember it fairly clearly. I might have some of the details mixed up, but I was in the passenger seat of the car, and the driver was making a left-hand turn into a driveway on a curved street. And on that curved street, there was a man on a motorcycle who was traveling down the curve at a high speed. And as he was traveling down the road, we were making our turn into the parking lot, into the driveway. And I was watching, I saw the guy on the motorcycle the entire time. And it just looked like, we were going to miss each other. But it didn't happen that way. The driver had slowed down, and this cyclist was at a high speed rate. So smacked right into me, right into my shoulder, my whole head. I got the whiplash, the glass shattered and smashed all over into my head. I was picking pieces of glass out of my scalp for months, maybe even years after that. About a year or so after that. And no blood, anything like that. Just some blood from some scrapes and scratches from the glass. But anyway, what I remember that incident. If I were to get, I was never called to court for that crash, but that was dealt with. I was the passenger. I don't know. I could have maybe, gone to court, but anyway, it just didn't turn out that way. I didn't pursue it. The guy on the motorcycle was way more severely hurt. I was more traumatized by seeing him laying on the ground motionless when I was getting out of the car. And that freaked me out. That is what freaked me out the most, was that. And he did have some very serious injuries, lifetime permanent injuries, a cane, and, you know, I think he had a skull fracture, like all kinds of things. It was terrible, just terrible car accident. It was horrible. I'll never forget it. But it's not something, it didn't cause any brain injuries or brain damage, so it's not something that replays in my head. It never was something that replayed. I would actually have to make the effort to think about it and recall it. So it still works that way for me. Now, I would imagine it could be different if I was the dude on the motorcycle. He might be experiencing some serious flashbacks and PTSD from that experience. And I saw it happen. I was part of it, so I could totally see how that would happen. But I didn't. I wouldn't consider... The only thing is that I was afraid to be a passenger in a car for a long time. I was a very paranoid passenger, but I still did it. But I was always like, you know, is there anybody coming? You know, can you hurry up and finish that left turn? You know, move faster. Make sure nobody hits me. But I think that's just a normal outcome or consequence of such a thing. But it's not something where I would, you know... consider legal action for, or have my entire life and future just blame that, you know, anything that went wrong in my life because of that accident. I never would have done that, never did try that. So yeah, it's too sad, too bad for people who really do have those memories that never go away. Okay, hold on a second. Alrighty, guys. Well, I've gone over the hour. I'm not sure if you're still there. If you have any other comments on this case. Let's see. Oops. Did I close that? Oh, I must have. Everybody who's dealt with a traumatic event remembers clearly the event. You don't forget it. So how come children forget sexual trauma? Well, yeah. See, the explanation they use is that nowadays is that you choose to forget it because it was so traumatic. That's the new terminology that people are coached by victim advocates, sexual assault centers, even crowns probably guide you in that direction when you're being questioned. I don't know, or at least they expect the victim witnesses to prepare you for that question. So it's a whole line of, you know, successive people that a complainant works with in order to, by the time they get to trial, they are perfectly coached to answer questions and to expect certain questions to be asked, and kids too. And then coached on how to answer those questions. You can see it in many cases where you have access to the police statement and then the trial, because months and years go by in between the initial police statement and the trial. And during that period, there's a lot of coaching between all of these victim services people, you know, people that get together and discuss their experience. Oh, here's what you say it this way, or here's the answer that you give to get around that. You give it that way. Because you'll be asked this and you'll be challenged on that. And so they have a lot of preparation, a lot of people helping them, and money in their bank account. Yeah, traumatic events are remembered. I absolutely agree. I just think in terms of like flashbacks of it coming at you, I think the only time a flashback is legitimate is, again, there's the context, but the flashback of truly traumatic events that you never forget. I think it's a circuitry in your brain as a result of that traumatic event, but a physical result, not a emotional result. It's something that comes back that you don't want it to. If you could control something emotionally, you would tell it to go away. If you are unable to control something emotionally, it's a crossed wire in the brain. It's a defect in the brain that was caused as a result. And you have to get that from something seriously traumatic, like some sort of war zone injury or car crash, something like that. So, but the context of flashbacks that they're using in these types of cases is that is how the memories resurface. They resurface in a flashback as if they hadn't thought about it for many years. That's very different than experiencing a traumatic event and continuously reliving it from the moment you experience a truly traumatic event. So it's a completely different context, and it boggles my mind that the courts will actually entertain and allow the commingling of the two types of traumas together, a legitimate trauma and one that no, it's not legitimate. I mean, personally, wouldn't it be interesting if in a sex assault case like the one that I just reviewed here, a witness that was brought to the stand was somebody with an actual traumatic brain injury or an actual traumatic physical, bodily injury where they lost a limb or, had a piece of their arm blown off or had to watch a friend get blown up in front of them, or have a true, brain injury, which occurs commonly in war zones. Bring them on as a witness to explain what post-traumatic stress disorder looks like or what a flashback actually looks like. And wouldn't that be an interesting way to get the judge or the jury to truly contemplate the difference between what this complainant is describing as a flashback of trauma and what this witness, a war zone vet, an ex-soldier, is describing as trauma? Suddenly you're going to sit there feeling very humbled, wondering why the hell you're even there, aren't you? That would be an interesting tactic. I'd like to see somebody try that. Black Knight Fool, which makes unlikely that a woman would accuse another woman unless it was more serious. It still happens, though. Yeah, maybe. But it still happens. I've seen, female and female molestation cases in run through the courts and in the news. They do happen. Yeah. So, Logic MK, whatever happened to the reality of shell shock? Those people never forgot what happened. They relive it constantly. That there is actual trauma. Yeah, shell shock. Whatever happened to that? Good question. I would like to see an alleged, victim of having unconsenting sex or being touched sexually for a sexual purpose describe their experience of that as shell shock. I haven't. I don't think I have. Maybe it would be kind of weird. That would be a tough one to explain, wouldn't it? I would argue that none would feel more sexually abused than any other person. Maybe. Because they're socialized to see virginity as such a special thing than other women, it will actually be more traumatizing. Yeah. They are socialized to see virginity as a special thing. Yeah, but, as we know, people who work in churches aren't always all that clean, Nuns and priests and whatnot. Shell shock is World War I jargon for what is now PTSD. Yeah. Yeah, but it's the PTSD that's being misused. Yeah. It's unfortunate. But again, it's by design, people. Don't think that these are just simple, uninformed mistakes that lawyers and courts are just uninformed and making, innocent mistakes when evaluating this type of evidence and determining whether or not a person's convicted, guilty of a crime. No, I'm sorry. I can't buy that. This is by design. The courts need this jargon and lingo and these, theories in order to exist and operate and justify building multi-million-dollar courthouses with, you know, rigged up with high tech, for all of, you know, the increasing crime rates, and, you know, we need more police to do this, and we need more police for that, and, you know, we need more of this, we need more of that. They're just looking to pocket more money, get more funding, and, you know, these terms, these psychiatrists, these psychologists, therapists, you know, these police, these are all part of the fabric of allowing and justifying the court systems to operate the way they do, and the police as well, unfortunately. So I can imagine how it would be very offensive and insulting to someone who truly is a victim of PTSD or some sort of brain injury, to see cases like this being taken seriously the way they are. I could totally go with that. I'm waiting for the first case where a bipolar person to press charges against themselves for the first time they masturbated. Har. The SJW invasion of religion has already started. You have to warn them. Yeah, well, warn who? the SJWs? When a person is charged with a sex crime, innocent until proven guilty goes out the window. Sure does, David. Sure does nowadays. Although there are a lot of police officers who will not move forward with a case. They will actually investigate it before pressing any charges, or something will happen that, you know, it won't make it worth their time to pursue a conviction and pursue an innocent man, a highly probable innocent man. So last I looked, I haven't looked at 2017 or 2018 statistics because I don't even know if they're out yet, but about 70%, maybe 75% of people, sex assault claims that make it to a police precinct, a police division, never result in charges. So we can all take some solace in that. However, the feminists and the, you know, feminist legal scholars and people who are interested in keeping these bread and butter cases running through the courts, they will beg to differ. They will make you either think A, that doesn't exist, or B, all those police are wrong in turning those cases away and not pressing charges. That's what we're fighting. And new, younger generation police officers that are starting out on the police force have already been indoctrinated. They've grown up in this culture, and they've been indoctrinated to basically, you know, treat any sex assault case as a highly probable case that it's true, but you're not going to have any evidence to prove it. There rarely ever is any evidence to prove that it happened, so you're just going to have to operate to the benefit of the complainant, and don't ask her any questions that might make her feel re-victimized, and don't look into her history. Don't ask her about therapy. Don't ask her about, you know, doctors or pills, medications, addictions, alcoholism. Don't ask about any of that. And they won't. They just record the complaint. They're a record maker. Quote, only 2% of rape allegations are false. Oh, God, that's a whole other, you know, one of these days I'm going to make a video just on that. That completely baseless claim. You know, it's totally taken out of context. Yeah. And it's shared amongst all Western countries, too. They all use the same 2%. So, yeah, you can't tell me that 2% rate is the same for every Western legal system. Nope, it's derived from one report, and it's applied to all of our legal systems. Yeah, and it's misinterpreted data. We all know that. I know I'm preaching to the choir here. Anyway, guys, all right, so this has been an interesting case. As I said, I made a mistake in introducing this case as a Supreme Court of Canada case. When this particular case I read tonight is not. It is an appeal court of Ontario case, so it's next level down. So I'm going to fix that on this video. I will be editing that. And yeah, you'll have a link to the case. And if I do dig up a subsequent Supreme Court decision that came about with this case, I will add that link as well. But I'm not sure that there is. So anyway, that is your more prominent appeal decision in a case specific to therapy-induced alleged childhood memories of rape or sexual abuse of some sort. This is the most cited case that I can find relevant to that exact specific topic. So in other words, there's not a lot of this in our case law here in Canada. It's very difficult to find. All right, so I hope you guys all learned something from this. Thank you very much for watching, and don't forget to upvote this video. And if you're watching for the first time, please subscribe. I would love it if you would like to subscribe and be notified of new upcoming streams and content that I will be uploading and putting out there for you guys to watch. I've got tons of topics that I want to do, just not enough time, unfortunately. So yeah, again, everyone have a great night. Thank you very much, and we'll see you next time. Bye bye.